Welcome to the Law of Contracts Part 2, a continuation from the Law of Contracts in Kenya, Part 1. And we have certain goals to be attained by the end of this video. As you can see from your screens, today we set out to discuss breach of a contract and the remedies for breach of a contract within the Republic of Kenya. Now, with this in mind, I want us to move ahead to discuss enforceability of contracts. And before we discuss enforceability of contracts, we had a chance to look at types of contracts in the previous video, and we shall recap these key definitions. So we have a type of a contract which can be a void one, and this means the whole transaction is regarded as one of no consequence. And then also we have avoidable. So you see we have void, then we add voidable. So this is useless from the very beginning, while this can be valid until a party takes steps to avoid it. That's why we call it voidable. So it operates as a valid contract until a party takes steps to avoid it. Then lastly, we also have an enforceable contract, and this one is valid, but it cannot be enforced in court if one party refuses to carry out its responsibilities. Now, with these types of contracts in mind, I want us to have a look at analysis in the Kenyan situation, so that we appreciate our own local law, because either way, when we sign contracts, they affect us based on Kenyan courts. So our first case analysis was a case on breach of contract, and it is a case between Vincent and Diamond Shield International. Now, the facts of this case were that Vincent claimed that he entered into a contract with Diamond Shield to supply antivirus worth 15,800,000 as per Diamond Shield's local purchase order dated 25th June 2013. Now, Vincent went ahead to claim that by cancellation of this LPO, there was a breach of contract. Now, remember, Diamond Shield had made an offer to Rose, and Rose went ahead to reach out to Vincent and asked Vincent whether he could supply antivirus. Vincent goes ahead to meet Rose at a bus stage. He is handed over a local purchase order belonging to Diamond Shield, and this local purchase order is addressed to Vincent. So you see, according to the facts, it's clear that up to this stage, Vincent had not met the actual person who wanted the antivirus. Remember, as we discussed in our first video, that the traditional method of determining whether the parties have in fact agreed to be bound by a contract is to ask whether one party had made an offer and the other had accepted. Now, with that in mind, remember the offer was made to Rose and not Vincent. So Rose, it seems that was a go-between person between Vincent and Diamond Shield. And for that reason, the judge found that the contract failed to have offer and acceptance. Remember, in the previous video, we discussed the rules governing offers, and one of them was that an offer should reach the offeree. So Vincent and Diamond Shield had no interaction directly, and there was no offer between the two parties, and for that reason there was no contract. So the next case is going to bring a proper understanding of what a void contract is. Remember, as we discussed also in the previous video, legality was one of the elements of a valid contract, and the case of Joseph versus Wamboi, the court has simply stated that the law will not enforce an illegal agreement. So please, if you're transacting in an illegal agreement, even if you sign it and that subject matter that forms the basis of that contract is illegal, the courts might not be able to help you should that contract be breached. Now, furthermore, I want us to look at a case analysis on avoidable contract. Remember, as I stated earlier, avoidable contract is valid until a party takes steps to challenge it. Now, what might be these steps, or what would inform you taking these steps? If you entered a contract under threats, or if you entered a contract under duress, meaning that it was not your intention, or rather you were forced or coerced to sign this contract, and you could have done this for fear of personal suffering, you can later on go challenge that contract, and it will be avoidable contract. Remember, duress is all about illegitimate or unlawful pressure, and where proven, the related contract is deemed voidable. Now, I think you can see clearly what we mean by a void contract, avoidable contract, and an enforceable contract. For any further questions on this, please reach out to me on my email. Now, before we conclude this part of the video, I want us to look at breaches and remedies. And remember, in any contract you sign, you might encounter a minor breach, you might encounter a material breach, you might encounter a fundamental breach or an anticipatory breach. Now, with a minor breach, this one, the remedy will be actual damages. For material breach, that means you can sue for specific performance or recover damages. By specific performance is that when you sue, the court will force the other party to fulfill their duties accordingly. With a fundamental breach, this goes to the root cause, the main reason why you signed the contract. And if there is a fundamental breach, this permits the other party to terminate the contract. And lastly, we have an anticipatory breach, and this simply means if there is a future indication of non-performance, then you being the aggrieved party, you can start legal proceedings before actual breach occurs. Now, please remember that the law of contracts in Kenya will become clearer to you in preceding videos, and for today, this is what we had for you. Remember to subscribe to Nairobi Legal, and we are happy to serve you. Thank you.